Hello, everyone. Thanks for joining our webinar on probate, on the probate process. I'm Shannon McNulty. I'm the founder of Village Law Firm and an estate planning attorney. And at our firm, we specialize in estate planning and estate administration. I also have with me my colleague, Joe Stackhouse.
Hey, everybody.
So we want to have this webinar really because a lot of times we hear about probate and the probate process, and we hear anything from it's very simple, so there's no need really to worry about it, to it's a complete nightmare, and we have stories of probate lasting over 10 years. So we kind of wanted to look at what that actual process is, and also when is it complicated? When is it not as complicated? What makes it complicated? What are the things that we have to be on the lookout for? When do we really want to avoid it? When is it not really going to be as much of a problem? So Joe has been working on a lot of our probate and estate administration processes lately, and he can certainly share the stories that we have and some of the issues that have come up. This is one of the areas where it's tends to be a little bit colorful when we have probate issues that come up. Okay, so going to desktop. Let's share my screen in a minute. And Joe, maybe we could just start with kind of what are some of the first questions that we ask when somebody calls us and says a loved one has passed away?
Very, very first question we ask is, where did they reside when they passed away? Because that will determine what court, not just, with or within the state, but also which county surrogates court we need to file in, and then we have to look up those specific rules and protocols. Typically, we also ask, where the asset's located, was there any trusts? In that way we can determine even if probate is even necessary.
Yeah, so there are two main types of assets when we're going through this process. So one is probate assets and the other is non-probate assets. So what are some of the, I guess, what does those two terms actually mean? And can you give us some examples of them?
Yeah, so a probate asset is an asset that will need to go through the probate process in order to be distributed. Non-probate assets are assets that will not have to go through probate, obviously. But the way an asset can avoid probate is a couple different ways. First, if an asset's jointly owned with a decedent, and what that means is jointly owned bank accounts, jointly owned real property, anything that would automatically transfer to a joint owner as soon as that person passes away, that property doesn't have to go through probate. Any bank accounts that name a transfer on death beneficiary, a transfer on death beneficiary designation just says that when I pass away, this account will automatically go to this person or this trust. Those will also avoid probate. Any other asset where you've designated a beneficiary. Very recently in New York, you can now name a transfer on death beneficiary on a deed to property. So you can name a trust or a person who will collect, who will get the property when you pass away, and that will help it to avoid probate. And then finally, assets that are held in either a revocable living trust or an irrevocable trust, that will also help those assets avoid probate. Any asset that, for the most part, doesn't fit into one of these categories will be a probate asset and will have to go through probate in order to be distributed to your loved ones.
Okay. So yeah, so I think like non-probate, it has to be a particular type of asset, or it has to be has a beneficiary designated on it. And then probate is kind of a catch-all. So anything that's not non-probate asset is going to go through probate. So a lot of times people ask us, well, do I have to update my will every time get a new house or change assets or anything like that? And the answer is really no, because in your will, generally, you just say everything that I own goes to so and so. So it covers everything that may not be in a non-probate category. And then in terms of the residence so once we have that we actually have assets that need to go through probate, then we can look at what is the residence of the decedent, because if we have to do a probate, then it's very location specific, and that has to be where the decedent had resided at the time of their death. Okay, and then we want to look for, we ask, is there a will? And we have to make sure that we do some due diligence to make sure that there wasn't a will. We do the person has to basically go through the apartment and see if there's anything, any wills or any evidence of a will, to see if that person had a last will and testament that they prepared. So what happens, Joe, in terms of, so say they found a will, so what happens then?
So if they have a will, first thing, never, ever, ever remove staples from a will, unbind a will. The court needs an original will in order to admit it to probate. If the will exists, then we determine the value of the assets. And if there is over a certain amount, then it will go through a regular probate. If it's below a certain amount, it will go through what's called a small estate procedure, which is a much more simplified procedure. And then
Who does all of these things? Like, who is the person who, like, what do we look for in a will? Can anybody just take this will and take it to the court?
No, your executor, the person appointed in the will, is the executor. So we'd want to know who is appointed as the executor in the will.
Okay, and then they're kind of the one who works with the lawyer and make sure they're kind of responsible for making sure that everything gets taken care of. Is that?
Yep.
Yeah, right. Okay. And if there is no will, then what happens then?
Then we have to do what's called an administration, where we look for potential parties who qualify to act as what's called the administrator of the estate. So generally, if you're married, that would be your spouse. If you are not married or your spouse has passed away, it would be your children. And then we would go through that whole list of family members until you find the person who can act as administrator of the estate, which a lot more time consuming, a lot more collecting information, a lot more people you have to notify. So not having a will is definitely not a good thing.
Okay. And I want to sometimes we talk about probate, sometimes we talk about estate administration. I think in sort of the public at large, those two concepts are interchangeable, but legally, is there a difference there legally?
Yep, probate means there is a will. Administration means there's no will.
But the process is somewhat similar, but it's just referred to as a different type of process. Okay, so once say the executor has the will, and we want to look at, is it, like you said, an original will? It cannot be a copy of a will. What do they do then? Kind of what is that? They bring it to us. Kind of what is the next step of that? What's that look like?
So once we've determined whether a probate or administration is necessary, and then we determine whether a regular probate or administration or a small probate administration is necessary, then we'll prepare and file all the paperwork with the court. The information typically we need to include is if there's a will, who is appointed as the executor. We'll need to include the names of all the closest living family members of the person who passed away. We'll need to include the names and contact information for anybody who was listed in the will as a beneficiary. And then we'll also need to include the value of the estate. That's how the court determines how much to charge you.
Okay, great. Okay, so we prepare this petition, we submit it to the court with the executor does it, and we work with the executor to make sure all of that is done properly. And I guess before that happens, what can happen before we file this petition? Can the executor do anything?
No, you are pretty much whatever assets are considered part of the estate. So all of those probate assets are pretty much frozen until the court appoints somebody who has permission to manage them.
Okay, so we prepare and file this petition, and then what do we do?
We wait.
We wait. And
Sometimes a
sometimes we
long
wait
time,
and we wait and we wait, right?
sometimes a long time, depending on different courts in different counties. It can take a while. It can take, up to a year sometimes. But we wait until the court gets back to us. If the court needs additional information, they may reach out and say, we need this, 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 and this, and then we fulfill those requests. And then the court vets everything, make sure everything's been filed properly, and then they send us a certificate officially appointing, if it's a will, the executor, if there is no will, the administrator, officially appointing that person to act on behalf of the estate.
And what is that document? Is there a title for that, like
It
authorization?
is called letters testamentary. And that's the official certificate which says that you are able to act as executor or administrator.
And administrator, I think it's called letters of administration.
Letters of administration.
But it's the same thing. It's just an order from the court saying that this person is authorized to act on behalf of the estate. Okay, so we get this, and we're kind of going overview of like this is pretty simple process, assuming that nothing is complicated. Okay, so then as the executor, what is the executor's next step? Now they have this order from the court.
They'll start gathering the assets. They'll open an estate bank account. So the estate will have its own bank account where it will hold a lot of the funds, if not all the funds of the estate. And then they'll start making sure they know where everything is, where all the assets are located. And they'll start paying debts and expenses and taxes before anything can be distributed out of the estate. The government wants their money. Any lenders or creditors, they'll want their money. And so they'll need to also take some time and find out who those creditors are, etc. Typically, the court says you should wait 7 months from the day that you receive letters testamentary, so that from the day you're appointed as the executor, you should wait 7 months before making any distributions from the estate, and that allows time for creditors to bring claims against the estate.
Okay. So, and if I decide, well, I'm just not going to pay these expenses or taxes or anything, and say I'm the beneficiary and I'm just, well, I'd rather just get the money myself than pay the IRS or pay the credit card bill or back rent or whatever. Can I just distribute the money to myself or distribute it to other beneficiaries?
Generally, no. You can get in trouble for doing that because you are, for at least for that 7-month period, you are responsible for those debts and expenses. If you do make any distributions and a claim, especially in that 7-month period, a claim or the government comes back into the estate looking for that money, you'll have to do what's called a clawback, where either you'll have to claw back assets into the estate, or even if you've taken some yourself, you can be personally liable for doing that.
Okay, so we've seen that where money was distributed, and then the executor then can be, somebody comes after the executor basically, and maybe they don't have the money anymore. Maybe they've distributed it all to the beneficiaries, and now they would basically be on the hook for those debts. And so that's one of the reasons why it's really important to make sure everything is accounted for properly, and also to get proper advice to make sure that you don't end up being liable. Okay, so we got this, the payment of debts and taxes. Okay, and then what happens after that?
So then you'll inventory what's left over. You want to make a record of where the different bank accounts were and how much was in them, and now where everything sits in the one estate bank account. You'll want to know what the value of that account is, in addition to the value of any real estate, any, sort of personal property. So that way you have a full record of all the assets that you are in charge of as the executor or as the administrator. And then you'll prepare what's called an accounting, which is very similar. You'll list the inventory of the assets. You'll also list out different expenses you've paid, different taxes you've paid. You'll also list things that may still be owing. And this sort of gets you to that number of what's going to be distributed. So you've accounted for where, what you started off with, what's been taken out, what is still left to be taken out of the, to be used to be paid for taxes, and then what is left over to be distributed out of the estate.
Okay, great. So we have the accounting, and does that have to be like, what types of accountings are there? Is that just like a piece of paper with all of the transactions on it, or does that have to be something like that involves the court?
So when everybody's getting along and things are going smoothly, you can do what's called an informal accounting. And that is just you prepare, either with the help of your accountant, your attorney, whoever else, you prepare a explanation of, where different things have gone. And that most of the time you just pull off your bank statement from the estate bank account. And that's something that you'll show to the beneficiaries, and the beneficiaries just give a thumbs up and say, this looks good, I'm ready for my distribution. And that will get attached to what's called a receipt and release, which is an agreement between you as the executor and the beneficiaries that says, I'm distributing this money to you, I'm distributing these assets to you, I've provided you with accounting of all the work I've done and where everything went. Once you sign this, you can't sue me. If things do not go well, there's contentions about, well, the house was supposed to go to sister A, but it ended up going to sister B. When there's disagreements, then the beneficiaries can compel what's called a formal accounting, which is an accounting that you will file with the court. The court will intervene and they will determine, have you done everything you were supposed to do? Have the assets gone to the place that they're supposed to go? Has everything been distributed correctly? And that takes time. That takes, paperwork with the court, and it also takes money to pursue that. But generally, when everything's going smoothly, everything's getting along, the estate is very short, sweet, and simple. An informal accounting is all you need.
And that's basically the receipt and release is kind of a waiver that I'm not going to sue you for the administration of the estate, and I've gotten what I'm supposed to get. Okay, and then like you said, if somebody decides, oh, I don't want to sign this release, then we have to go through that whole like judicial accounting process. Okay, already. So I say I'm a beneficiary, I sign this release, then do I get the money at that point?
Once we, yeah, as the attorneys or the executor, once we receive the signed release and a receipt and release, you would get your portion of the distribution. So you would get your assets delivered to you either through a check or through a deed or however they might be transmitted to you.
Great. Okay, great. So that is assuming everything goes perfectly, there's no problems. Even here, I just want to look at like who has to sign things, like what is this actual process? So when we prepare the petition, what do we actually do with that? Does anybody have to sign off on that for the appointment of the executor?
Yep. So the executor will sign it, basically saying that the information contained in it is true to the best of their knowledge, saying that they are the person the will has appointed as the executor, and they're the person asking to be appointed formally by the court as executor. We as the attorney also sign the petition and other documents. We certify that the documents have been prepared correctly, that we are the ones representing the executor in the court process, etc. So both us and the executor sign the paperwork.
Okay. And then it needs to be served upon, the will needs to be served upon certain people as well.
Yes. So
Yeah.
one of the documents we prepare for the process is called a notice of probate. That is a document listing, all the people who have rights under either as this will or as a family member. We serve them with a copy of the petition for probate and the notice, and we also will include a photocopy of the will with that so that they can see the will for themselves. In addition, if you have a revocable living trust or another trust that is involved with the probate, you'll send out a copy of that as well.
And then they have to sign that. They have to sign any kind of waiver of their rights or anything like that.
Depending on the situation, they may have to sign, if it's an administration, in other words, it's an administration, and so there could be a class of people who all have the right to serve as administrator. Whoever is asking to become administrator, they would need to sign a consent and waiver saying, I'm okay with, I'm okay with so and so being the administrator. I'm going to waive my right to be administrator.
Okay. And the deceased heirs, they get a notice of, and they can be either, basically, they have to be a service of process unless they waive the service of process. And that's basically their opportunity to file any objections. Yeah. So even if you are not named in the will, say, we have a client and they said, I really want to, I really don't get along with one of my siblings, and I want to leave all of my money to my other two siblings. So say there's three siblings, no kids, then that sibling that was cut out of the will still gets notice. So they still have to get notice. And that's where it can be, they might not agree. They may make it difficult. They may make it, they may not agree to waiver of service. So you have to have like a formal judicial service on them. Then they may feel like, okay, this is a chance. I don't like this will. This is not a good will for me. I'm cut out of here. So they might say, well, I want to contest this will. So that's sort of, then they have opportunity to object. And so that's where cases where there is somebody who may inherit what we call intestate, meaning that their beneficiaries named as if there was no will. They would have received, they have a kind of a pretty big incentive to contest a will, because if the will gets knocked out, then they will inherit the assets. Alrighty. Okay, we have a question, but I want to get through the slides and then we'll take questions. I want to get through everything. So, okay, so in terms of, we talked about how long this process takes. And we were seeing before pre-COVID, we were seeing in terms of getting the big issue really, if there's no complications, is just getting the letters of administration or the letters testamentary from the time that we filed the petition. And that was taking, I would say, 3 to 6 months pre-COVID, maybe even shorter in some counties. And then we were at well over a year for a while. Some counties we still are at well over a year, and some counties have started to kind of get back to where they were pre-COVID. So it really varies depending on whether there's complications, but also what county you're in. So New York County is one of the better counties. So we're starting to see, I would say a couple of months, we're getting approval from the court at this point, depending, but it always depends. Sometimes it can be longer and we just don't know why. But where there are delays, there can be a lot of problems. And this is where we see a lot of problems with the probate process. So one of them is there's just no access to money. So if all of those assets were probate assets and mortgage needs to be paid, rent needs to be paid, kids need to be taken care of, all of these things. Lawyers need to be paid, all kinds of expenses, funeral bills, things like that. There's no access to money, and that causes a lot of problems. Inability to pay real estate expenses, like I was saying, there's no ability to pay mortgage, no they need the money to pay insurance, property insurance, property taxes. We've seen properties go into foreclosure because this process is taking too long. The inability to sell stock. So those assets are frozen, and if the stocks are not in sort of a more diversified portfolio, the estate can lose a lot of money during that time. And finally, if there's a business, this is where as well we see a lot of problems that the whole business can be stalled. So there's no access to operating accounts, no ability to sign paperwork. So the value of a business can basically just plummet if it's in this estate or estate administration or probate limbo. Anything to add on that, Joe?
No, that sounds all right.
Okay, so we kind of talked about that process, if there's not a lot of complications or there's no complications. But I want to go over where the complications start coming up. One of the most common is that we're unable to locate the original will. And when this happens, that we're in a day and age where we're used to copies of everything are fine, even electronic signatures are fine. In the probate court, there is not, we're not quite in the 21st century yet. We're barely in the 20th century, sometimes I feel. So if they can't find the original will, even if they have a copy of it, it's really difficult to submit that will to the court. The court is likely not going to admit it. And so that can basically be the whole plan has just gone down the drain because it's basically like there is no will. There are a couple exceptions to that. One, if you can prove that the will wasn't revoked, that's really, really hard to do because you're trying to prove a negative. And if the will was in the custody of a lawyer, the lawyer can sign an affidavit that they had custody of the will. And so we know that the deceased person hadn't revoked it. So that's one of the benefits of having a lawyer store your will. There's some downsides to that because things go wrong, but that's one of the reasons why you want to make sure you always have the original will and somebody knows where that will is located. Another complication is if there's minor children or an incapacitated person. In this scenario, the court will require the appointment of what's called a guardian ad litem. And that is the person that is paid out of the estate. It's generally a lawyer that is appointed and chosen by the court to represent the interests of the children or the incapacitated person. And sometimes this person, the guardian ad litem, it can cause a lot of complications, a lot of delays. They often are they're basically representing the interests of the children or the incapacitated person. They're looking to see whether the will was properly executed. They're looking to make sure all of the I's are dotted, T's are crossed. They may want to interview the lawyer who prepared the will. They may want to interview the witnesses, a notary. So that can cause a lot of delays. Also, when a guardian ad litem is appointed, generally a formal judicial accounting will be required. And in that accounting, every penny has to be accounted for to be approved by the court. And also it's all public information. So once you have a judicial accounting, that's one of the differences between having kind of the informal accounting and the judicial accounting. The judicial accounting becomes public information. So that's maybe you don't want the whole world to know exactly how much money you're inheriting or your kids are inheriting. Okay, unable to identify and locate heirs at law or beneficiaries. I think Joe, you're dealing with this in one of our cases right now.
Yes, absolutely. We have a case where we thought the decedent had no family, and turns out they have cousins that we need to include. They're entitled to notice as her next of kin. So we have been Googling obituaries to find out who these people are, how they're related, preparing family trees. We've gone on Facebook and Facebook stalked these people to find out how they're all related. Um, it is a pain in the neck. And then once we find out who they are and how they're connected, then we have to find the right phone number for them or the right address for them. And then we have to call them and say, hey, are you related to so-and-so? And thankfully, in some circumstances, family members have been extremely helpful, giving us information on, oh, so-and-so lives here and here's their email address, here's their phone number. If you need help, contacting them or finding out how they're related, because that's the other thing with all of these people. And we have to include the lineage. So we have to say in our petition, so-and-so is the first cousin, the daughter of this person, who is the brother of this person, who was the father of the decedent. We have to include all of that information in the petition. So when we're calling these people, we have to confirm their lineage and how exactly they're related. And it's very time consuming.
Yeah, so this is kind of where you have, especially like a single person, they don't have kids. This is where we really want to probably try to avoid probate because we can end up with a very cumbersome process and lengthy and costly process. Finally, where there's a lack of cooperation from, these are the heirs at law. The heirs of law are the people who would inherit if there had been no will. And so these are some of these people and be cousins scattered far and wide that they may say, oh, well, now I know, I may not know before, but now I know that I had, that my aunts died and maybe I can inherit if there was no will. So they may give a hard time. They may not provide a waiver of the notice of the probate. They may require a formal accounting. So there's a lot of things that they can object to and we can cause problems with. Okay, where there is a charitable bequest in a will, we have to notify the state attorney general, the department, the Bureau of Charities. So this, it's great to leave charitable bequests, but it's maybe not so great to leave them in your will because that's going to cause complications. Blended families. So this is where we see a lot of contention, even where people were getting along previously, maybe they're not getting along so well afterwards, where we have a second spouse and we have kids from a previous marriage that we see a lot of times that this is kind of ripe for conflict. Assets in multiple jurisdictions, particularly where we have real estate in multiple jurisdictions. Joe, do you want to explain kind of what happens when in that case?
Sure. So each state has their own rules involving probate, and they have their own protocols, etc. So depending on where you have assets, if you have a real estate in Florida and you have real estate in California, etc., you have to go through probate in each of those states. So you would start probate in your home state, where you resided, where you passed away. And once the court approves you in that jurisdiction, then you need to take that letters testamentary to the jurisdiction where those other assets are located, bring it to a court there and say, hey, there's a house here in Florida. I need to put that through probate to distribute it. And so you'll have to begin a concurrent probate in that other state. Yep.
And I'll add as well, even if we have sort of one thing, if it's in other states, and then we have even other issues when it's in different countries. And in that case, then there's a whole lot more complications that arise. And sometimes we have assets or property in the US where somebody lived abroad, and it can create a lot of problems. Other drawbacks, lack of privacy, of probate expenses, administrative burden, and an emotional toll. So if somebody has just lost a loved one, then they're really not looking to, it can be really difficult for them to have to go through a very burdensome process. So that's really why when our clients come to us, we want to make the process as easy as possible. And that's usually why they're coming to us ahead of time when they're doing their planning. Is like, we don't want our kids, our loved ones, whoever it is that we're leaving our assets to have to get stuck in a lengthy, expensive court process and have to be grieving at the same time that they have to be dealing with lots of lawyers and fees and things like that. So when we're looking at, often clients want to avoid this process entirely for reasons that hopefully are clear by now. And there are a few ways to do that. There's really two main ways. One is you have assets that are, you make assets have beneficiary designations, you have them owned jointly. That's kind of a first line of planning. It can be very simple. The other way is through a revocable living trust. And that's kind of like a will, but it avoids the probate process. A transfer on death or beneficiary designations can be really good solutions where it's a very, very simple situation, where there's not going to be any estate tax issues, where there's really only one beneficiary, maybe two beneficiaries, and everybody gets along. Otherwise, we generally don't recommend this for larger estates. You really can't do any tax planning. You can't do much in terms of disclaimers. You can't plan for the New York estate tax cliff. Sometimes people name charities that are no longer in existence, and then it ends up back in the person's estate. If a beneficiary predeceased, there's not as much contingency ability to do contingency planning. If there's minor beneficiaries, generally that's going to end up back in the court if a minor beneficiary was designated. And one of the other things is there's no funds to pay expenses and there's no one in charge. So we leave everything through, say sometimes we see somebody has 5, 7 accounts and they say, well, I've just named the people who I want to receive everything as beneficiaries of each of these accounts. So who is going to be the person who's responsible for paying for your funeral, arranging everything, cleaning out your apartment, dealing with all of your personal items, paying taxes that may be owed. There's kind of nobody in charge. And so that's one issue. And then the other issue is who's paying them, because whoever puts that money out, they don't necessarily get it back. So if you're an executor or you're a trustee of a revocable trust, then the trust can pay that before they distribute the money out. And the other issue with that is that you may have a certain amount in each of these accounts right now, but 10 years from now, those accounts are going to look very different because often you have to take withdrawals from an IRA or a 401k. Other accounts may vary. They may go up in value, they may go down in value. So what you're doing at any one time is going to be changing the next day, literally. So that's another reason when we have more than one beneficiary, or definitely more than 2 beneficiaries, we don't really recommend this type of planning. And then finally, some of the things that we do with a revocable trust or other types of planning is asset protection. So leaving assets in a trust to protect against a divorce or to protect against other creditors. We can't do that through just a simple beneficiary designation. So we can do those things, all of those things through a revocable living trust. So for most of our clients, that is a better way to structure the estate. So what happened there? Oh, it just went away. then Joe, do you have anything that you want to add to that?
No, I think you pretty much covered everything.
Okay. Right. And then some of the things like Joe pointed out, there's just a lot of things as well in probate that can go wrong that you might not even imagine. Like Joe said, if the staples are removed from the will, then we have to find out who removed the staples. We need to submit an affidavit from the person who removed the staples as to what happened and make sure that they didn't change any pages. We've seen judges, if there's a date that's wrong on the will, then we have to get an affidavit from the drafting attorney. I've seen cases where the witness's name was not printed clearly, and the court rejected the will. So there's just all kinds of things that can go wrong with the probate, and that's really why it's there. It can serve a really important purpose, but generally it's not the best solution. So we have a couple of questions here that I want to get to. Okay, if the main beneficiary of the will is me or my spouse, we'll just say it's me, can I be the executor administrator? Joe, you want to answer that question?
Yep, absolutely you can. Generally there's no conflict if your executor is also the primary beneficiary of your will. In fact, typically what we do with our wills is we put your spouse as the primary executor after you pass away, and then likewise they're also one of the primary beneficiaries of your will or of your trust. So no, there's no issue there.
Thank you for the very interesting topic. I'm interested in specific cases of clients residing overseas and owning real estate property in New York. You mentioned the residency sets the place where probate is started. Would probate not be started in New York if real property is in New York, even if last place of residence was Europe? There would be two separate procedures going on. Correct. So there needs to be either we need to have somebody appointed as the executor or administrator, whatever the equivalent is in the country where the deceased person resided. If in many cases we've seen there is no person that's not a process. There is no executor appointed or administrator appointed. People just automatically inherit the assets. And in that case, we need to get an affidavit from an attorney in that country to be able to do the probate in New York. In addition to the probate in New York, we also need to file an estate tax return because there are likely estate tax issues where somebody did not live in the US. But it can be a very complicated process. So that's why you definitely want to prepare in advance and we would recommend having two wills in that case, a will in the place where they reside and a will in New York. Does having a revocable trust limit your ability to do anything with the assets while we are alive? No, a revocable trust is, as the title says, revocable, meaning you can change it at any time, you can terminate it at any time, you can take the assets out at any time. So there is there's no limitation. Unlike other types of trust or revocable living trust, it does not have any limitations on what you could do with the money. It's just the same as if it's in your name. For unmarried couples, no official domestic partnership, can the partner be the executor if there are children? Yes, the partner can be the executor. And it kind of depends, are there minor children? The partner can be the executor if you appoint them in your will. If there is no will, then they cannot be the administrator. The children would be the administrator. So it really depends, but you can appoint them as the executor in your will, even if you're not married. Okay, and then we just have a couple of thank yous. So I hope that this was helpful. If you have any other questions, we can put them in the chat, and otherwise we can wrap up. Okay, thank you, everybody. I hope that this has been helpful. And if there's anything you have any further questions, feel free to reach out, or if we can be of any assistance, we're happy to talk to you.
Thank you, everybody.